Major breaking news out of the state of Texas and great news for the Second Amendment's right to keep and bear arms. Attorney General of Texas, Ken Paxton, has just filed a motion to withdraw his appeal from a lower court victory in favor of the Second Amendment, where 18 to 20-year-olds were declared to have the right to be able to carry guns in the state of Texas as part of the people, as in the right of the people to keep and bear arms. Stay tuned. I'll break it down for you when we get back. Hey folks, I'm Mark Smith, host of the Four Boxes Diner, proud American gun owner, constitutional attorney, member of the United States Supreme Court Bar, and New York Times best-selling author. If you have not subscribed to the Four Boxes Diner Second Amendment channel, please do so. Show your love for the Second Amendment. And also, we're working really hard to try to get to 100,000 subscribers. It'll make a big difference for this channel in terms of the social media algorithms. Okay, guys, we have great news. We have some bad news last week, but we have great news this week. We go back and forth, just like a sporting event, except ultimately, we're going to win this one for the Second Amendment. So today, down in the state of Texas, you may recall what happened back in August. We covered that. Back in August, a judge in Fort Worth, Texas, named Mark Pittman, issued a powerful decision that said that Texas' statute that says that 18 to 20-year-olds are generally not allowed to carry guns under the concealed carry regime, if you will, down there in Texas, that statute, that restriction on the ability of 18 to 20-year-olds to be able to carry guns under that rule, under that law, was unconstitutional. And therefore, 18 to 20-year-olds would be allowed to carry guns consistent with the rest of Texas law, just like any other Texas adult. This is a major victory back in August because it was one of the early decisions that applied the Second Amendment after the decision in NYSERDA versus Bruin, and Judge Pittman did a great job, and we're going to talk briefly about that methodology in just 1 second. But the bottom line is, let's go back to where we are right now. In August, Mark Pittman said 18 to 20-year-olds are entitled to carry guns like every other Texan under the Second Amendment's right to keep and bear arms. There was a Texas law that said no. The judge says that law was unconstitutional and could not be enforced. The Attorney General's office, I suspect at the urging of the Texas Department of Public Safety, I think that's what they're officially called, the Department of Public Safety, I suspect at the urging of the Department of Public Safety, noticed an appeal, which just basically meant that when the time period allotted, the state of Texas says, we intend to appeal. That was not a full-blown appeal. It was just basically a notice that you intend to appeal. Now, I covered this and I said I thought there was a good chance that was not necessarily going to stand. I thought they might withdraw the appeal. I said maybe this was because they thought strategically they could get a good victory for the Second Amendment out of the Fifth Circuit Court of Appeals. It wasn't clear to me what the ultimate decision was. A lot of people were upset that they noticed the appeal. I said it was premature to be upset because I thought it needed a little time to play out. And lo and behold, it's played out in our favor. What do I mean by that? Well, Ken Paxton, the Attorney General of Texas, has said that in his view, basically, the lower court decision by Judge Pittman, the Federal Judge Mark Pittman, was correct that 18 to 20-year-olds do have Second Amendment rights and they do have the right to carry, and that Ken Paxton's Attorney General's office, I presume, concluded that they do not feel they had a strong leg to appeal on, and therefore they're conceding this argument, they're conceding this point in favor of the Second Amendment. So basically, remember, when you're the Attorney General or you're any prosecutor in the Texas Attorney General's office, you swear an oath to uphold the law. Yes, but in particular, you swear an oath to uphold the United States Constitution, the Second Amendment, the Texas Constitution. And of course, if a law is inconsistent, you do have a duty to defend the Texas laws as enacted by the Texas legislature as a general matter. But when such a law is enacted that violates the clear mandates of like the Second Amendment's right to keep and bear arms, you obviously have a duty to uphold the superior law. And as we know, there is no higher law in the United States than the U.S. Constitution itself, which of course includes the Second Amendment. So bottom line is, Ken Paxton here has, and I give him great credit for doing his duty, right? He has filed a motion to withdraw his appeal. I should notice, I've read this here, it's entitled an unopposed motion to withdraw the appeal. It specifically says that no party opposes the withdrawal by the state of Texas, which tells us that the plaintiffs in this case, and I'll read them to you, Aiden Andrews, Jordan Blakely, and the Firearms Policy Coalition. Congratulations, Firearms Policy Coalition. Firearms Policy Coalition for another major win here. They've consented to the withdrawal of the appeal. I think that makes a lot of strategic sense if you apply the rule that a bird in the hand is better than two in the bush, as they say, because obviously this is a major victory for young adults in the state of Texas. There's no risk at the Fifth Circuit could get a bad panel or something crazy could happen up there. One never knows for sure. I think the Fifth Circuit Court of Appeals is actually a very good court when it comes to guns. Nevertheless, no guarantees in this life, and they basically, by this withdrawal of the appeal, this guarantees a victory for young adults in the state of Texas. And I should mention that the analysis that Judge Pittman did was very good. I'll just spend 1 minute on this to remind you how to interpret the Second Amendment when it comes to these cases, other than gun ban cases, which has a slightly different methodology, which we'll talk about elsewhere. But for the purposes of the methodology, Judge Pittman got it right. The way he said it was this. You look at the text of the Second Amendment, it says the right of the people to keep and bear arms shall not be infringed. He then says that the question is, what did the Supreme Court think the people meant? He goes to the Heller decision in 2008 and says, guess what? The U.S. Supreme Court concluded and defined the people to include all Americans, all Americans. So therefore, presumptively, all Americans, including 18 to 20-year-olds, had the right to keep and bear arms. So then Judge Pittman says the burden shifts to the government for the government to show that going back to the founding period, there was some long-standing tradition using historical analogs that 18 and 20-year-olds could not carry guns in some way, could not have guns. And obviously, when he looked at the historical analogs, not only could the government fail to prove any historical analogs, it actually demonstrated just the opposite. Because if you go back to 1792, 1 year after the enactment of the 1791 Second Amendment, in 1792, Congress passed the Militia Act of 1792 that said that 18 to 20-year-olds were part of the militia, which meant they had a duty, not just a permission, but a duty to go out and acquire firearms, ammunition, and the like, to own privately in case they needed to go to the militia muster and bring those with them. So obviously you cannot acquire guns if you don't have a right to get guns. So basically, Judge Pittman says, among other reasons, the Militia Act of 1792 shows that 18 and 20-year-olds have a right to keep and bear arms. The text says yes, and there's no historical analog that says otherwise. In fact, the history in the 1792 era, the late founding, the founding period, actually suggests that they absolutely had a right to keep and bear arms. So you had the text victory for the Second Amendment, the historical victory for the Second Amendment, and a victory for the Second Amendment for the Firearms Policy Coalition and the other plaintiffs and all 18 to 20-year-olds today and henceforth down in the state of Texas. And I do congratulate also Ken Paxton for doing the right thing here. I give him credit. It's not always easy to refuse to defend a state law on constitutional grounds, but sometimes it's warranted. I think it was certainly warranted here, and I applaud Ken Paxton, the Attorney General for Texas, for upholding his duty that he swore, his oath to uphold the U.S. Constitution, including the Second Amendment. Okay, I hope you learned a little bit something here today. If you haven't subscribed to the Four Boxes Diner, please do so, and we'll see you again soon here at the Four Boxes Diner.
Orders up. Table 2A.